So I've been driving for 10 hours, just checked into the hotel. So that's why I look like crap. But I wanted to point out some things in Pavarotti's video about the 16th supplemental request for discovery. So let's take a listen.
When you actually look at it and take it for what it's worth and you dive in and look at what it actually says and you decipher it, it turns out that that little court doc for supplemental request for discovery tells us almost every single thing that we want to know. You just got to actually look and research it. Or you don't, because you got Pavarotti.
Yes, we've got Pavarotti. Yet again, misunderstanding documents. What a surprise.
I'm going to blow your mind. Ann Taylor's going to try to get Brian Kohberger bail.
No, she's not. Let's take a look at Idaho law, shall we? So according to the Idaho Constitution, you have a right to bail, except for capital offenses, where the proof is evident or the presumption great. Kohberger has been charged with 4 counts of capital murder. He is not eligible for bail.
And you're not going to believe what all it tells us, because it tells us a lot. And we don't even need to see Exhibit O to figure most of it out. And the reason I want to do this is, again, it's almost like like I've been saying, when we put stuff out there into the world in our videos, it has impacts. I mean, what have we been saying? I've been saying, look, they have not ruled on the alibi yet. And we need to get that out in front of everybody, because that's the most important thing in this case. And we haven't heard about it. Nobody's talking about it. Well, no sooner than I said that did they file this supplemental request for discovery. And it's almost like I'm on Ann Taylor's wavelength, because she put all the code in this thing for us to be able to decipher exactly what she's saying.
So he's claiming that this 16th supplemental request for discovery deals with all of that. And he's going by all of the parts of the U.S. Constitution and the Idaho Code and Constitution that she mentions in the document. However, he keeps forgetting that that's boilerplate language that appears in all the supplemental motions for discovery. Because in order to compel discovery, you put down the rights of the defendant. It's cut and paste. Let me show you the very first supplemental request for discovery that was filed. So here was the first supplemental request for discovery, clear back in February of 2023. And you'll see all of that listed about the Constitution and the amendments, and Idaho Code is the exact same boilerplate language that's in the 16th supplemental request that Embry is breaking down. And here's a few more. They all have the exact same boilerplate language. I'm not going to post all 16 motions, but you can see that this is not specific to that particular request. How comical that he actually thinks that because he put a video out that Ann Taylor suddenly put out this supplemental request. Neither the prosecution nor the defense cares what any of us content creators put out. They're not watching our videos. They're certainly not putting out documents based on anything we're saying in our videos. So keep that little ego in check there, Jay, because I guarantee you Ann isn't putting out supplemental requests for discovery based on your videos, or mine, or anyone else's. Now, with that said, I will give credit where credit's due. Jay did go through all the parts of the Constitution and Idaho Code that were mentioned in the document. However, that doesn't mean he's interpreting things correctly. Let's take a look at an area where he gets it completely wrong.
So he cannot have any witnesses or any professional, but any what am I saying? Expert witnesses to testify on his behalf as it relates to the alibi. The state's trying to say other than the defendant as to the defendant's absence from or presence at the scene of the unalivings. So the state is trying to force the defendant to testify on his own behalf if he wants to raise an alibi claim, if this is ruled upon that way. And it says right there in this Fifth Amendment that he should not be compelled in any criminal case to be a witness against himself.
Okay, you're completely misinterpreting that. The state is not trying to get him to be a witness against himself. This is not about him incriminating himself. They are saying that if he can't provide by that alibi deadline, like the who, what, where, when, why, like witnesses, etc., that then he's the only one that can testify to his whereabouts. That would be him testifying on behalf of himself, not against himself. Okay? So if you have an alibi and you're put on the stand and you state what your alibi is, you're actually trying to help yourself, not incriminate yourself. So no, the prosecution is not trying to get him to testify against himself. So that's not a violation of the Fifth Amendment.
So if that affirmation of statements in the probable cause are not true and the officer who did it had taken an oath, which they all do, then no warrants should have been issued because it's then considered unreasonable search and seizure. So, what are we talking about here? We're talking about the search and the seizures of Brian Kohberger's phone records, his house, his apartment, and his arrest warrant. And why is that the case? Because probable cause has been violated by the affirmation of the oath of the officer.
Okay, so if it turns out one of the officers lied and obtained a warrant through a lie, that's not handled through a discovery motion. That's handled through a Franks hearing. Again, you're like, all these constitutional amendments are put down on there and the Idaho Code are put down on there just as boilerplate to cover all the language on every supplemental request for discovery. It's not specific to this 16th request. And if she's going to challenge the warrants, that's not through a supplemental request for discovery. Here's what a Franks hearing is. So here's a refresher on the Franks hearing. It's a hearing to determine whether a police officer's affidavit used to obtain a search warrant that yields incriminating evidence was based on false statements by the police officer. It's derived from the case Franks versus Delaware. Supreme Court held that in certain defined circumstances, a defendant can attack a facially sufficient affidavit. Now, Franks hearings do have specific criteria that has to be met in order to get granted one. So it will be interesting to see if Anne actually will be granted a Franks hearing in order to challenge any of the warrants. But the 16th supplemental request for discovery is just that. It's a request for discovery. There's nothing deeper to it as far as bail, which he can't be set bail because it's a capital case. Capital murder case. That means cases that are eligible for the death penalty, whether they're pursuing it or not. He had 4 charges of capital murder. He's not eligible for bail. There's nothing in there indicating that it has to do with the alibi. There's nothing indicating that it has to do with any sort of upcoming Franks hearing request. So you criticized other creators for saying that it was just another supplemental request. Well, that's the bottom line. It's another supplemental request for discovery. You're misinterpreting again. as usual. Peace.